it's an interesting topic as far as the different things that are done to create these mitigation plans. And so just some of the things that are done to do that. One of them is limiting the rights of the foreign entity share ownership. Sometimes this can be provisions that are actually put into the charter of a even public company that basically prohibits a foreign entity to own over a certain percentage of that entity, and basically disenfranchises the foreign entity from any further ownership. So if they own over 20%, for example, anything they own over 20% cannot vote. If people want, in one way, an example of this, and just to throw something out to look at if you're interested in how this might be done in a public company charter, I would point you to the charter of Centrus Energy Corp. Certificate of Incorporation, which is filed on the SEC site on their Form 8A, filed on September 30th, 2014. Centrus is a uranium enrichment company, which is obviously a very highly sensitive and national security concern entity, and they have this issue regarding foreign ownership. The other things that might be done is you might limit, on a much more minor and less invasive scale. There might be limits as to the foreign entity's access to information. There might be limits to the foreign entity's control over decision making. One thing that is sometimes done here is setting up a proxy board, which is basically a separate board that is given control over issues that are critical to domestic infrastructure or security concerns. And then something that is fairly common is that there would be periodic compliance audits and certification provisions in any FOCI plan.